ACC Corporate and Business Law. Till now, we have covered chapter 1 to 4. Chapter 2 was a bit lengthy chapter. Other chapters are not that much bigger. So let's move toward chapter 5, agency law. Agency law. What is agency? According to agency, there are two parties. One is called principal and other is called agent. There are two parties, principal and agent. Principal hire or engage agent to perform some services on behalf of principal against any reward. Like in a company, shareholder or principal who engage their agent mean directors to perform some services mean manage their company against any reward. Mean shareholder are called principal, and on behalf of principal who is acting, who is managing their company, agent mean directors. This means if directors is making any contract with the third party like customer supplier, that contract will be on behalf of principal mean shareholder. Mean principal is A, agent is B, and if B have signed any contract with C, so that contract is between A and C rather than B and C. Because B is just a agent who is finalizing that contract on behalf of principal mean A. So what is agency? Agency is a theory where one party principal engage another party agent to perform some services against any reward. This means there is an agency relationship between principal and agent. And being an agent, what he need to do everything with best interest of the principal. He shouldn't consider his best interest. Mean there should not be any conflict of interest. He should always work in best interest of the principal. So let's see, what is agency law? Who is agent? An agent is a person who is authorized to act for an other mean principal in the making of legal relationship with a third party. An agent is a person who is authorized to make any contract with a third party on behalf of other mean principal. The resulting contracts are made between the principal and the third party. Principal and third party, and not directly with the agent. An agency relationship exists in lots of situations. A director act as an agent for the company. A partner act an agent for the partnership. How? We will study in next chapter today. Next chapter is on partnership. All the partners are agent of the partnership business, as well as agent of other partners as well. An estate agent is appointed by a seller of a house to find a buyer. In a property business, estate business, the property person who is finding a buyer of the property, he is acting on behalf of the seller, mean owner of the property. A travel agent is appointed by a holiday company to make a booking with customer. Like in UAE, if you want to book, suppose cruise dinner, you cannot book directly with the company. There are some agent in between you and that company who will book a cruise dinner for you. Obviously, they will be charging some commission from the company. How the agency relationship arises? An agency relationship can be established in any one of the 5 ways. Agency relationship can be through express agreement. Mean both principal and agent have written down something. They have stated everything. Okay, you are my agent and you need to do this. I will pay you against this. Could be implied agreement. Mean not expressed, implied. If a person is doing something on behalf of other, he is implied, like in case of property business, state agent, they are employed. By necessity. By necessity. What does that mean? We're going to discuss in detail later on. By ratification. Ratification means approval. If any other person, principal agent, if this person agent, mean Mr. A, is doing something with a third party and saying I am doing this on behalf of this principal P, while there is no agency relationship between them. Even P does not know about that he is doing with a third party something on behalf of me. Mean principal is not aware that a person is acting with a third party and saying he is my agent. But afterward, if principal want, he can approve those transactions that agent have performed with the third party. This is called agency by ratification, mean approval by the principal after. If he want, he can deny. But he want, if he see there is benefit, he can approve that. I mean, the person was not agent of principal. But after performing some transaction with the third party C, if principals are aware about this, he either can reject, mean deny, no, he is not my agent, or he can accept, yes, he is my agent, mean he can approve in case of benefit. That is called agency by ratification. Or there is another case, agency by estoppel. Agency by estoppel. There is another concept, agency by holding up. What are these? We're going to discuss later on. So agency relationship could be formed through express, mean written agreement, through employed, like a person is doing a work like agent, by necessity, in case of emergency, to save the loss of principal, by ratification, mean not agent, but afterward principal can approve, by estoppel, by holding out. What does that mean? We're gonna discuss these things later. So express agreement, this is where principal actually appoint A as an agent. The agreement can be made orally or in writing. Mean they have discussed the terms with each other. Implied agreement, this is where principal has not expressly agreed that A should be their agent. However, the agreement can be implied from the parties' conduct or relationship, like if a state agent is finding buyer for your property, even there is no written agreement between you, like I will pay you this kind much commission or something like that. So that will be according to industry norms is working as agent. By necessity, what does that mean? There is a party called P principal and another party called agent. P asked A, P asked A, please transfer some of my goods to some place. Transfer of goods. So P asked A to deliver, to transfer some of goods of P to some place. That place is too far. It takes few hours to deliver over there. While delivering on the way, there was a heavy storm. Storm mean the weather condition was not stable. So what A did? Instead, he is transferring his goods in normal way. He is unable to transfer the goods due to stormy weather. So he is having two options. Either he keep on moving in the storm, in the bad weather condition, but those goods could be destroyed due to bad weather. But he's having other option. He hired some space somewhere on the way and put that goods, put that stock in that store and paid some rent for the store. After paying the rent, he asked principal for the amount of it. Principal cannot deny because A is his agent in case of necessity, meaning in case of emergency, to save the loss of principal. If any person is working to save the loss of principal, he will be called agent by necessity. So this requires four conditions to be satisfied. P's property is entrusted to A. Mean P have handed over his property to A to transfer to somewhere else. An emergency arises, make it necessary for A to act. Mean A did something in case of emergency. Obviously, bad weather, storming weather is an emergency. If he don't do anything, he don't put the product in any of the safe place, ultimately they will be destroyed. So there should be emergency, and due to emergency, a agent have acted something. It is not possible to communicate with P. Obviously, due to that stormy weather, he was unable to contact with principal. I'm talking about old days when there was no mobile. There was only one way of communication through letter or through telephone. And in stormy weather, it was difficult even to connect a call through telephone. Mean it was difficult to communicate with P what way I should adopt. Either I should put these products in a storehouse for rent, or I should keep move on. And third, A act in the best interest of a principal. Mean he tried to save the loss of principal. Whatever A acted, that is in best interest of principal. Mean to save the loss of principal. If these conditions are fulfilled, then this person will be called agent of principal. He is acting, he is behaving on behalf of principal. First, P has handed over any property to transfer to Mr. A. A acted in emergency. It was difficult to communicate with the principal, and A, whatever he does, that was in best interest of the principal, mean to save loss of the principal. And there is a case, Prager versus Bloodspur. A bought skins, animal skins, through which leather can be produced. So A bought skins as the agent for P, but was unable to send them to P because of prevailing war conditions. I mean, this case was at the era of World War I. So P asked A to purchase some skins for me. So A bought the skins, but was unable to deliver to the P on time due to war conditions. Since A was also unable to communicate with P, he sold the skins before the end of the war. He sold the skins before the end of the war. And saying, I sold because I was working as your agent. This condition was fulfilled. P property is entrusted to A. Was there any emergency in which he sold? No, he could put it to the store and wait until the war end. Okay, this condition was fulfilled. Whether he acted in best interest of the principal? No, he needed the skills. His requirement was to get skills. So what court decided? A was not an agent of necessity because he could have stored the skins until the end of the war, and there was no real emergency. And in second case, Great Northern Railway versus Swafield. There was a contract between the two parties whereby Great Northern Railway, means railway company, agreed to transport the defendant's horse to a particular railway station from where it would be collected. In this person, Swafield handed over his horse to this railway company. Please deliver to certain place, certain station, and this name person will collect the horse at that station. What happened? When the horse arrived at that station, no one arrived to pick up. So what railway company did? The station master, having tried unnecessary to contact the defendant but failed, placed the horse in a stable overnight so that the horse could be safe there, and he paid rent for the stable. Now this railway company is asking this person, the owner of the horse, for the rent of the stable, but he is denying, no, you are not my agent. What they did? First condition fulfilled. Obviously, if at the station nobody came to pick up, there was emergency where they can put the horse. They acted in best interest of the principal because they saved the horse at proper place. What is the proper place for horse is stable. So railway company was entitled to recover the cost of stabling because it had become the agent of the defendant by necessity. So agency can be formed through express agreement, through implied agreement, by necessity. But in by necessity, four conditions must be fulfilled. P has given his property to agent. There is an emergency in which agent have acted something. Agent tried his best to communicate with the P but failed. And agent did everything in best interest of the principal. Agency can be formed by ratification. Ratification means there are two persons, and this person A is performing some transaction with Mr. Z and saying, I am performing this transaction on behalf of P, while there is no agency relationship between P and A. Afterward, if P is aware about this act, like he is performing some transaction with Z and saying he is performing on behalf of me, mean he is my agent, he either can deny, no, he is not my agent, and inform Z, or he can approve, yes, he is my agent. Obviously, if he is getting some benefit through this transaction, he will accept. If he is accepting, that is called agency by ratification, mean by approval of the principal. If a properly appointed agent exceed their authority, or P appointed A as his agent and have defined some authority, up to this amount you can perform transaction on behalf of me. But agent exceeded his authority. If he has exceeded his authority, this means he is not working as agent. If P is aware about this, he performs some transaction by exceeding his authority. Either P can deny or he can approve, me ratify. So if a properly appointed agent exceed their authority, or a person having no authority, mean he's not agent, purpose to act as an agent, the principal has no liability on that contract, mean he can deny, unless the principal ratify the contract or he can approve the contract. If he has approved, then A is his agent. But he has denied, then A is not his agent. Who is responsible for transaction between A and Z? A and Z only, not B. Is that clear? And he is not agent and performs some transaction on behalf of him. Or he is agent, but he performs some transaction beyond his authority. In both cases, principal, if aware, either can approve, be ratified, become agent, or deny, mean not agent. The effect of ratification is backdate A's authority to act as agent. Obviously, if he ratified whatever the transaction from this date till previous A performed, principal will be liable for those transactions because he approved now. This requires P to have the contractual capacity to make the contract. Mean P should be in a position to have contract with Z, have been in existence both when the contract was made and at the date of ratification, and P should be present, should be in existence when he is ratifying and when those transactions were performed, when he was not principal. Be identified when the contract is made. And P can be identified. Okay, this is P, either company, either person. Be aware of all the material facts, and he's aware what A have performed transaction with C. Clearly signify their intention to ratify the whole contract within a reasonable time, and he should clear his intention properly. Yes, I am approving. Note that a void or illegal contract cannot be ratified. Only legal contract can be ratified, not illegal. And there is a case between Kellner versus Baxter. The promoters, who are promoters? Who promote the company? Mean at initial stage of company, when company is going to form, they promote the name of the company. They try to sell share of the company. The promoters of a company entered into a contract on behalf of a company before it was incorporated. In the promoter performed some transaction with Mr. Z before the company mean principal was incorporated to purchase some property. The other party was not paid and they didn't pay. So mean this was a company. This was Mr. A in promoter. They signed a contract with Z to buy property from Z and said to Z, we are buying this property on behalf of P company. They transfer the property, but they didn't pay the full amount. Z sued the P company because they were working on your behalf. So there is contract between you and me. But P was not aware. Even that P mean principle was not in existence. They were not in existence. So now even they cannot ratify it. Because for ratification, principle should be existed at the time of the transaction and at the time of ratification. So as the company did not exist at the time the contract was made, the company could not ratify the contract even. The promoters were personally liable to the seller. He will ask, please sue them, not me. Because I cannot even deny, even I cannot accept because I was not in existence at that time. Because company formed after, incorporated after those transactions between A and C. What is meant by agency by estoppel? This arises where P principal hold out that A is their agent. This principle is saying to other party Z, A is my agent, A is my agent, A is my agent. Saying to the world, A is my agent, while A in fact is not his agent. And there is no agency contract between P and A. And if they, means Z, perform some transaction with A as he was aware he is agent of principal, and this Z suffered some loss, he sued principal for the loss. Now principal cannot deny he is not my agent. Though he is not his agent, but he cannot deny because he speak out to the world, he is my agent, he is my agent. But in fact, he was not agent. This is called agency by estoppel. In reverse, there is called agency by holding out. Agency by holding out. What does that mean? If A is saying, I am agent of principal P, A is saying, I am agent of principal P in presence of P, while he was not agent. In a gathering, A said to the public, I am agent of P. P was also there. P just smiled, didn't deny he's not my agent. Now, if A performed any transaction with third party Z, Z can sue P because he couldn't deny at that time. If A was not your agent, you should deny it. You should speak at the moment, no, he's not my agent. But if you, instead of denying, just smile, this means you giving your consent like, yes, he's saying right. While in fact, he was not your agent. Now he will be liable. Estoppel, in estoppel, principal speaking, he is my agent while he is not his agent. In holding out, agent speaking to the public, I am agent of him while he is not agent. In both cases, principal will be liable for any loss of property. He will not be able to deny. So by estoppel, this arises where principal hold out that A is their agent even though they are not. P is then prevented or stopped from denying A's authority. He will not be able to deny after that if he performs something. That's your understanding one. Peter advertised his car for sale in a local newspaper and then went on holding, leaving his car in the drive. He advertised, my car is for sale, and then went on holiday, leaving his car in the drive. While Peter was away, Tom, having seen the advertisement, went to look at the car and decided to make an offer for it. Peter's neighbor, Alf, pretending to act with Peter's authority. He said, I am Peter's agent, so I can sell car on behalf of him. Entered into negotiation with Tom and eventually accepted Tom's offer on Peter's behalf. Alf had no authority to act in this way because he was not agent. When Peter returned from his holiday, he wrote to Tom saying that he was ratifying Alf's act. This is what agency by necessity. Agency by necessity, agency by ratification. By ratification. Advise Tom as to whether he is bound by the contract. Yes, if he has approved this mean, though he was not agent, but if he has approved, this means this is agency by ratification. So let's move towards authority. Mean what kind of authority agent and principals both are having in agency law. The authority of an agent is a central issue in the concept of agency. How much authority he is having, what he can do on behalf of principal. It determines the power that the agent has on behalf of the principal. Mean authority depend upon the power given to the agent from the principal and for which act the principal is liable and which act principal will deny or not liable. If the agent exceed their power that was given by the principal may still be liable to the third party because third party no is your agent. If you have given him authority, you can make transaction up to 100,000 only, not more than this. If above this, you need to involve me, I will see. In this was his authority. He performed transactions of 4,000. And due to this 400,000 transaction, third party Z suffered some loss. To whom he can sue for damages? Principal. Because if you are saying to agent your authority is this, not this, this is between you and agent, not for the world, not for the third parties. And if agent perform beyond that authority, third party are not aware of that. So they will claim damages from whom? Principal. But afterward, principal can claim damages from agent because he exceeded his authority. So if the agent exceed their power, the principal may still be liable to third party because they are not aware about the power limits, but they may have a right against the agent for breach of the contract, but he can recover from agent afterward. There are three ways in which authority may be given. Authority may be given through express actual authority. This is authority that P has explicitly given to A. Written, stated. Implied actual authority. An agent has implied authority to do things which are reasonably incidental to perform of an express authorized act. I mean, those are reasonable according to the express act. An agent occupying that position would usually have authority to do. I mean, he is performing in a way in which agent do something. Have not been expressly prohibited by P. I mean, P haven't expressly said to the agent, okay, this is not your authority, this is not your authority. This means there is implied authority. Our agent is having apparent or ostensible authority. Apparent or ostensible authority. Such authority arises where A agent is held out by P as having authority. Holding out. The representation by P may arise from previous dealing. Allowing A to make a contract in the past is a representation that A has authority to continue to do so. There is a case here. What you versus family. The new owner of hotel continued to employ the original owner as the manager. The new owners of a hotel continue to employ the original owner as the manager. In the agency agreement, the new owner ordered the agent not to buy certain items, including cigars. The manager still bought cigars from a third party. The owner then refused to pay for the cigars. But he was the manager. Before the change of ownership, what he was doing, he is also doing even after the change of ownership. Because he is agent of the owner. The purchase of the cigar was within the usual authority of a manager because that was given to him previously. The contract was binding on the owner. If a limitation on the usual authority is going to be effective, it must be communicated to the third party before any contract is. What is apparent or ostensible authority that is stated already. If you want to change, you need to state the new thing. If you haven't stated the new thing, then agent, if performing as per the previous routine, he will be your agent, mean you will be liable for those transactions. Mean if ownership is changed, the manager, whatever he was doing for the previous owner, he is also doing for the new owner. If you haven't communicated to him, like your authority has been changed, you cannot do this thing, then it doesn't affect the agent. You need to communicate. Freeman and Locker versus Booker Park Property Limited, F versus BPP. The defendant company had 4 directors. This company have 4 directors, none of whom had been appointed as the managing director. I mean, they haven't decided who will be the managing director. Because from the director, company need to elect one person as managing director, means CEO. One director effectively ran the business, mean he was more involved in running of the business by himself and entered into a number of contracts with the claimants. This person, mean he was representing the company and he involved into some contracts with the Freeman and Lockers on behalf of the business, BPP. On previous occasion, the board on behalf of the company had honored the contracts and paid the claimants. There was previous practice between this person and the company. They were having some contract with each other. They deliver goods and payments were made. In the similar manner, they perform these transactions. However, on this occasion, the board refused to pay, arguing that the director had no express authority to make the contract because he was not the managing director. Can they deny? No, this is agency by apparent or ostensible as per previous transactions. So, although the director had no express authority to make the contract, the directors had apparent authority. This was because by honoring the similar contracts in the past, the company, as the principals, had given the impression that the director had the authority to make this sort of contract. The claimant had relied on this representation by continuing to deal with the director as per previous dealing when purporting to act on behalf of the company. In court decided no, he was agent of the company. Breach of warranty of authority. Mean if agent breach some authority given to him, what will be the consequences? As discussed earlier, if the agent has no authority or exceed the principal may ratify the contract and become liable, or he can deny. However, if the principal does not ratify, then the agent will be liable to the third party for breach of warranty or authority because they warranted or promised that they had authority which they did not possess. Like, there's a company called Apple. There is a business called ABC Store. ABC Store selling iPhone to the general public and saying we are the authorized dealer of Apple, while in fact they are not authorized dealer. They sold some mobile to Mr. Z on warranty. Mr. Z is aware I am buying these products from authorized dealer, mean Apple company directly, indirectly. They move to Apple for warranty claim. Apple either can ratify or can deny. Or there was a contract between Apple and ABC Store. Apple allowed ABC Store, you can provide a warranty up to 1 year. What is their authority? Up to 1 year warranty you can provide, offer. But they offered 2 years warranty to the customer. After 1 year and half, after 1.5 years, they went to Apple for warranty claim. So Apple can deny because he performed a transaction beyond their limit. So who will be liable for that? ABC system. This is breach of warranty of authority. Liability of the principal and agent. Mean if third party suffered some loss, who will be liable for that loss? Either principal or agent. In normal cases, if agent performing transaction on behalf of principal, principal will be liable. Where the agent acts for a disclosed principal. Disclosed means principals have stated, yes, he is my agent. A principal is disclosed where the existence of the principal has been made known to the third party. It is not necessary for the principal to be identified to the third party. As a general rule, the contract is between the principal and the third party. The agent is neither liable nor entitled under the contract. However, the agent will be personally liable in the following exceptional circumstances. So when agent will be liable? Where the agent showed an intention to undertake personal liability, for example, by signing a written contract in their own name, then he will be liable. Trade usage or custom. Trade usage or custom in some market, according to the normal customs, according to the normal way of doing business, agents are becoming liable. Where the agent refuses to identify the principal. And who is the principal? He didn't mention to the third party. Where the agent is acting on behalf of a fictitious principal, fake principal, in fact, principal does not exist. Does not exist, who will be liable for third party? Agent. If he refused to the third party who is the principal, he will be liable. If he signed the contract with his name, he will be liable. And in some trade usage or custom mean according to industry norms. Where the agent act for an undisclosed principal. An undisclosed principal is where the principal existence to have not been made known to the third party. And when the third party discover the existence of principal, they can elect to treat principal or agent as bound by the transaction. He didn't disclose, but the principal found the third party found the principal by themselves. So they can sue both principal as well as agent. He is agent of a principal, but he doesn't disclose to the third party. Agent fiduciary duty. Fiduciary word is associated with the trust. Agent is a trusted person for the principal. So fiduciary duty means duty of trust that agent have to perform towards the principal. An agent has a fiduciary relationship, trust relationship with the principal, like he will do everything in my best interest. This is position similar to that of trustee. It has the following consequences. What are the duties of agent? Fiduciary duties. Agent must not allow their personal interest to conflict with those of P. He should not consider his personal interest. He should consider interest of principal only. This is his fiduciary duty, being agent. Agent must always act in best interest of principal. Agent must not make a secret profit. If there is any profit extra, you need to disclose him. Though you are paying the normal profit that is belong to principal to him, but if you gain something for yourself, you need to disclose to the principal. Agent has a duty to account to principal for all money and property received. Meanwhile, performing transaction on behalf of principal, whatever the property, money he has received, he need to disclose everything to the principal. There shouldn't be any hidden things. So he should avoid conflict of interest. He should work in best interest of principal. He should disclose secret profits. And he should communicate all the property and money to the principal. Where an agent is in breach of their fiduciary duty, what could be the consequences? Principal can repudiate, cancel the contract with the third party. Agent can be dismissed without notice. Principal can refuse to pay any money owed to A or recover any money already paid. And principal can recover any secret profit made by the agent because that will be considered as bribe. Right. Where principal liability, what are the principal's liability to the agent? The agent has the right, what he can recover from principal. He can recover from principal whatever the remuneration or commission that is agreed between them. Usually the amount of remuneration or commission to be paid is stated in the agency agreement. Where it is not specified and it is a commercial agreement, the court will employ a term into the agreement requiring a reasonable amount to be paid, according to the industry norms. If while performing transaction on behalf of principal, agent spend some money for the expenditure, he can cover that expenditure money from the principal. This is his right. To claim and indemnify against a principal for all expenses reasonably incurred in carrying out their obligations. To exercise a lien over P's property if he paid some of the expenses on behalf of principal and principal is not paying those expenses to agent, he can lien over hold the property, hold the product of principal. This is his right. He will release when he will get his expenditure back. So to exercise a lien over holding, capturing, custody P's property, the lien allows the agent to retain possession of P's property that is lawfully in A's possession until any debt due to agent, for example, arrears of remuneration, previous remuneration not still paid, have been paid by the principal. So he has three rights: to receive remuneration, to receive expenditure incurred while performing transaction on behalf of principal, or lien over the base property if there is any money unpaid. Chapter finish. So let's move towards some questions from BPP kit. 12.1. The purpose of an agency relationship is to form a business contract between which of the following parties? The purpose of an agency relationship is to form a business contract. The business contract will be between principal and third party. In order to form an agency relationship by express agreement, what form should the agreement take? Both oral and written? Yes. Express either oral or written. Not only oral, not only written. Holding out is a key element of which form of agency? Implied, estoppel, or necessity? Estoppel and holding out. Estoppel, principal saying he is my agent. Holding out, agent saying I am agent of this person and he is not denying, he is smiling. 12.4. Which type of agent authority is derived from what is usual or customary in the circumstances? Express, ostensible, or implied? Ostensible as per past transaction, as per past routine. Implied according to the industry norms, not expressed. 12.5. Tribes. Unless circumstances indicate otherwise, which party is not liable under a contract properly formed under an agency agreement? Who will be liable? Principal and third party. Who will not be liable? Agent, because he is working on behalf. So, unless circumstances indicate otherwise. Circumstances indicate otherwise mean agent have a signed contract with his name, principal was not there, something like that. 12.7, please. An agent may not enforce a contract that they have to form. No, he will perform the contract. This is wrong. A principal may sue their agent if the third party is in breach of contract. No, he will sue third party rather than his agent. A third party and principal do not need to be in direct contract for a binding contract between them to be formed. Obviously, in agency, they need not to be in direct contract. 12.8. Which type of agent run an accountancy practice? Audit firm, accounting business should be through partnership business. It cannot be registered as a company, either sole trader or partnership. So company director cannot be accountant or auditor. Partner, not commercial agent, not promoters. 12.9. Agency by ratification. The principal need not have existed when the contract was made. No, he should be in existence. The principal need not have had legal capacity when the contract was made. No, he should have. The principal must communicate the ratification of the contract clearly to the third party. Yes. At least half of the provisions of the contract must be ratified. No, no, no. 12.10. Which two types of agency are formed without the agent's consent? Implied, express, both consents are required. Estoppel, he is saying he is my agent, he is my agent, he is my agent, and he is not aware. In ratification, he has performed some transactions. 12.11. In agency law, which of the following statements relating to agency by estoppel and which relate to agency by necessity? There is no agency agreement, but the principal state publicly that a person is my agent, he is my agent, he is my agent. There is no agency agreement, but the principal looks after an other person's property when they cannot be contacted. Not a principal, it should be agent. Looks after another person's property when they cannot be contacted, mean not impossible to contact him. Necessity. Horse. 12.12. These two MCQs are wrong. Don't cover them. 12.14. Have you studied when agency relationship can be terminated? We haven't studied that. Let me check. Might we have missed something? When agency relationship can be terminated. No information regarding this. Let's study again. In which of the following circumstances will an agency relationship not be terminated? Agency relationship can be terminated through bankruptcy of the principal. Principal dies. Insanity, mean principal become insane. Unsound mind. Performed by the principal of their contractual obligation. This is the best answer. And 12.15. In which two of the following situation will an agent be liable on a contract? Where it is a usual business practice for the agent to be liable according to trading, usage, and custom. Where the agent act on their own behalf, even though they purports to the acting for the principal, means signed contract with his name. Where the principal intends for the agent to take personal liability, No. Where the third party agrees with the principal that the agent will be liable, no, they cannot agree with the principal, he will be liable. So that's it for this chapter. Let's take a break. After break, we will discuss another chapter. FR.